And when you say effective terms and conditions of employment, objectively, so that anyone would say would in that situation would be effective, and subjectively. So was it unwelcome or was it not unwelcome? So you have, and that is a gauntlet that is very difficult for any plaintiff to get through. All right, because there's so many traps and pitfalls. So these cases were set up practically for failure for plaintiffs. First, you have the EEOC, and when I say plaintiffs, employees. First, you have this whole administrative process where if you don't file within 10 months, then you don't have a federal claim. You got to go through the process. You got to file in federal court within the 90 days, or you lose your claim. And then, you have to prove all these things to satisfy your claim. Very difficult. So perhaps I would like to think, as a result of Me Too, that the law has changed. Now, what changed is the state law, New York state law. Ironically, Governor Cuomo made it easier for this to happen, and you may be regretting that now. But what happened was the law changed. The state law changed to match the city law, and the city law was already in place. So the city law said, you don't have to prove severe or pervasive anymore. You just have to prove that you were treated differently. And the employer's defense is that it was a petty slight, what happened, or a trivial inconvenience. All right? Petty slight or trivial inconvenience. So now it's much easier for an employee in a state law case to prove discrimination, especially hostile work environment, because of the law change, and let's hope that happens because of Me Too, and that's what happens. So I mean, when people get upset about it, say Me Too, all that, it doesn't really do much until there's enough of a groundswell that legislators and governors and people say, we got to make this change because people are upset and people want it. So that's how it works, and it worked here, and now it's much easier for employees to prove harassment and discrimination. Thank you.
Right. Now, this is what I want you to do, what I want you guys to do. If you raise your hand, I will sting here. I can see the hands that are raised, so then I will get to you. You have to keep your hand raised. So, Mike Weed, go ahead. You have a question?
Yes. Can you hear me?
Yeah.
Go ahead.
Okay. So I have some questions. Like in the case, like an employee is too young for a senior position. Even he is very, good at the job and meets all the qualifications, but he was overlooked for the position, for the promotion, because the position was offered to an older person with less qualification. So in this case, is it discrimination?
Okay, so under federal law, there is the Age Discrimination and Employment Act that only applies to employees who are age 40 or older. All right, you have to be at least 40 for age discrimination. It's to protect older people from discrimination. However, the New York State human rights law does not have an age limit on it. So I think technically you could file for age discrimination under the New York State human rights law, claiming you were discriminated against because of your youth rather than your age. I've never seen a case like that, but I think it could be filed. But just realize that the laws against age discrimination are, to protect against older people who are tossed out of the workforce and, in favor of younger people who maybe would be perceived as more energetic, and probably are, and will also be cheaper, right? That guy who's been at the company for how many years keeps getting raises every year. Now you can hire someone off the street, so to speak, for a lot less money. So there's the purpose of this was to protect older employees against discrimination. But I think you could file that at the New York State Division of Human Rights. Not.
It could also be like, I know that at the end of the day, the law is created by human beings. So isn't that almost like, I know about the Me Too movement. How about the Wait Your Turn movement, which is that a lot of people probably psychologically, subconsciously in their mind, they're like, okay, I know you're great for a 30-year-old, but, just calm down. Wait till you're 40. And, what I'm saying? There's like that subconscious thing of, you're young, you got your whole life ahead of you, you'll just keep working hard and you'll get there, as opposed to an older person getting overlooked because for a younger person, you can't say to the older person, well, you got your whole life ahead of you. They don't. So you think that that's part of it, like that psychological thing, and that's an undercurrent behind the difference between the younger person who gets messed up versus the older person?
Yeah, that could be too. That could be. Look, it could. There's in employment law, a lot of times you're navigating biases, right? That everybody has, and you may have biases in favor of younger people. You may have biases against younger people. I hear employers all the time, talk about how difficult it is to hire people. They can't get good help these days, and they'll give a variety of reasons. But then I often wonder to myself, well, is it everybody else out there, or is it you? Is it the employer who's got maybe unrealistic demands or expects too much or something like that? So it's difficult.
Okay, let's see. Rabiul?
Yes, Professor.
Go ahead, you have a question?
Yes, so I have actually one question. That is like, suppose an employer is rude to their employee, and it causes the employer to quit the job, and the employer left job after 2 years. Suppose they realize that actually the employee realized that or feel or know that he was like treated differently. In this point, like after 2 years, they can take any legal action to their former employer?
All right, so I'm trying to figure that out. So I think the employer was rude to the employee. The employee worked there for 2 years. And
I don't know I think what he said was the employer is rude to the employee.
right.
I think the employee quit. Is that what you said, Rabiul?
Yes, the employee quit
And then
after.
2 years later realized that they had been treated differently.
Yes,
Like it
yes.
was not just rude, they were actually being discriminated against. And 2 years had passed since he quit.
All right, so there's a couple of things there. Let's deal with the rude, and then we'll deal with the statute of limitations. So rudeness is not against the law, right? Employer.
Otherwise, New York would be illegal.
What's that?
Otherwise, New York would be illegal.
Yeah, exactly. Imagine that. Oh my goodness, we'd all be incarcerated by now. But employers can be rude, can be hostile, can be all sorts of things. Look, it's the employer's workplace. This country was founded by rugged individualists who came over here and through hard work made the country what it is today. We have this frontier sort of attitude in this country. It's different than other countries when it comes to that. And we believe that the employer, it's the employer's workplace is subject to certain laws. The employer gets to make the decisions in the workplace. Something called employment at will, which I'm sure you guys have heard of, which means that the employer can hire or fire at any time. And on the inverse of that is that the employee can quit or leave at any time. All right, so the employer can act really how the employer wants as long as it's not running afoul of a statute. So these statutes protect against discrimination, race, age, gender, religion, national origin, disability, sexual orientation, things like that. those are all protected by statute. So if the rudeness relates to somebody's religion or age or something like that, then the employee can file a charge saying, I was discriminated against. But if it's just sort of, garden variety, rudeness, yelling, screaming, demanding, that's not unlawful. All right, and besides that, there's also, health and safety laws, there's whistleblower laws, there's so there are other laws in the workplace too. So the other part of that question was, looking back, this happened 2 years ago. The New York State Human Rights Law was recently changed. First of all, in state court, you have a 3-year limitation period. All right, so if you're filing a state claim in state court, you have up to 3 years. It used to be, if you're filing administratively at the New York State Division of Human Rights, which is free, you don't need an attorney, and you could file any time. That used to have a 1-year statute of limitations. That is now 3 years also. So as of August of 2020, there's a 3-year statute of limitations for both. So yeah, if you realize it 2 years later, you can still file. But again, it's got to be for one of those characteristics.
Okay, hold on 1 second. I have to mute somebody. Okay, great. Thank you. Let me see who else. Katerina H.
Yes, hi, good morning. I had the question regarding the mandatory vaccination on the workplace. I had, what is the current situation? Were there any changes during last year? And can someone file a claim against their employer for firing because the person didn't get the vaccine? Personally, I am vaccinated, so.
All right. I am also I was surprised we're a half hour in before this came up. This is a big deal. I get many calls every day about this. And there are different mandates for different industries. From what I understand, and by the way, this is a very fluid process. It's changing, week by week, day by day. From what I understand, the federal mandates apply to employers who have 100 or more employees, and that has not been put into effect yet. But let's just deal with that first. So if the federal government says employers have to mandate the vaccine, there are always going to be some exceptions, and the EEOC has written on this already. And I'm going to talk about this next week, as a matter of fact. So there's always 2 exceptions. One is the medical exception, where you can have a medical exemption for the vaccine. Now let's just deal with that, because the doctors are not really giving you a medical exemption unless you have evidence that you're allergic to something that's in the vaccine. All right, so that's pretty narrow. In the past, medical exemptions were pretty broad. Now they're very narrow. And I had one recently with a kid who had a heart murmur or some sort of heart thing. And these vaccines are linked with myocarditis. And I sent him to a doctor I know who's very accommodating, and a doctor who is not reflexively pro-vaccination. In fact, she's not vaccinated. She may be losing some of her job because she's not vaccinated. So she wouldn't write the exemption for the heart murmur and for the vaccine. So unless you're allergic to a vial, to something in that vial or in that syringe, you're probably not getting a medical exemption. You might. Actually, I just had another case recently where somebody's platelet count was too high or too low, and the doctor said she can't get the vaccination now because of her platelet count. I think that would be a legitimate medical exemption. So aside from the medical exemption, there's also accommodations, you know. So an employee might say, you know, overweight, I'm older, I have asthma, I have diabetes. I cannot risk getting the novel coronavirus. So now there's an interactive process of how do we accommodate this employee. And this is a fact-by-fact assessment, and it's going to depend on the job. The employee always has to be able to perform the essential functions of the job. All right. So what is the job? Well, the job is such. If it's such that the employee can do it remotely, maybe that's a valid accommodation. But you know, if you're a nurse's aide, you know, you're not going to be able to work remotely. So an employer and employee can do an interactive dialogue to see if there's a way to accommodate someone who wants to avoid getting coronavirus and has a doctor's note. It's really up to the employer in that situation. You have to do how to accommodate, and if the accommodation is reasonable. And then finally, there is the religious exemption. All right, so I have on my system some pretty good religious exemption letters. I didn't write them myself, but I get some emails back and forth. I have a couple. Interestingly, just last night, okay, so in the medical field, everybody's required, if you're front-facing, if you're facing patients, you're required to have the vaccination. Initially, when the statute was passed, it had a religious exemption. 5 days later, I think it was Governor Cuomo again removed the religious exemption. So now everybody in hospitals has to get vaccinated, no religious exemption. Of course, you'll have the medical exemption, but that's incredibly narrow. So they went to court. Christopher Ferrara, a noted practicing Catholic, case for the St. Thomas More Society, took it to court, and actually won an injunction in federal court saying, no, you have to have the religious exemption. It was appealed to the Second Circuit Court of Appeals, which is an appellate court, and just yesterday they reversed that, saying, no, you don't have to include a religious exemption. By the way, I heard from several sources that a number of people applied for the religious exemption from Northwell Hospital, which is a huge employer here on Long Island and elsewhere. Northwell denied every single religious exemption. And now that this case has come down, the health and hospitals employers do not have to offer a religious exemption.
Okay, thank you.
All right.
Yeah, my wife is a nurse practitioner in Northwell Health, and she was telling me if you know anybody who's a nursing student, a lot of jobs opening up.
Yeah, they say this is happening on the NYPD too, and the fire departments. That these people are being mandated, and these folks, some don't want to take. It puts people in a very difficult position, right? Either your job, your livelihood, what you use to support your family, or the vaccination. I mean, it's tough.
You almost imagine a college student going to a career advisor and saying, what field should I go into? Look whatever fields people are being forced to get the vaccine and don't want to do it. Go into those fields. There'll be plenty of openings.
Right, but speaking of college, by the way, the young person, I don't know if I closed the loop on this, so the young person who didn't get the medical exemption used one of the religious exemption letters that I have on my file, and he got the exemption from the vaccine from his college.
Wow. Okay. So the bottom line of the religious is that it's being rejected in places like, well, obviously in healthcare,
Right.
but in college it might still be okay.
Right. Yeah. Yeah. Everywhere else, I think you're going to have. I mean, you have to have the religious exemption everywhere else, and you know, so if it's up to the employer, and I've heard cases like this, the employer saying, "Listen, we have to do this. Just write anything on a piece of paper about a religious exemption, and you're fine." Some employers don't really care if their employees are vaccinated or not. They just want something on paper to say, "Yeah, this guy was exempt and put in for religious exemption. We granted it." You know, or medical or something like that. So it's up to
What about the mask thing though? Like, can they say if you have to wear a mask?
So
I've always wondered how, like,
it's lifted in New York.
Yeah, you go into these restaurants and say you don't have to wear a mask if you're vaccinated, you whatever. I'm like always thinking to myself, I mean, you're opening up a can of worms here. It's like you know, people don't have a glowing orb on their forehead that tells you which group they belong to. So what does an employer do if, okay, they don't care if people are vaccinated?
But you have to care if you're in New York City, though, because New York City has its own statute. And it's I actually had to meet somebody at a restaurant in Brooklyn the other day, and you had to show vaccination cards and ID to get in. And I'm sure the students have seen this all over the place. So, you know, New York City has its own law. So it varies. It varies from, you know, from profession to profession, from geographically it varies. There's all sorts of...
just when you thought that your field was going to get kind of redundant, COVID came, right?
Yeah, yeah. And then there are COVID cases where people, I've had a bunch of them, for people who had COVID and were terminated. So that happens too. They have COVID, they come back, the employer says, "Oh no, you know, we don't need you anymore. It's okay," or, you know, "You're not allowed to come back." And that happened. And there was, you know, one of these cases I had was someone who worked at a hospital, big hospital in the city. And back then, this is early on, back then the rule was if you don't have a fever for 3 days, you can come back to work. Because there was no test at the time. And if there was a test, even early on, it took like 8 days to get the results back, you know. But this was before the test.
Can it ever get to the point where if somebody had COVID, that becomes a protected class?
No, I don't think. Well, yeah, in a sense, if it is a disability. So if you're what they call a long hauler, and COVID causes fatigue and affects your breathing and affects other things, now that's qualified as a disability certainly under the New York State Human Rights Law. Under the Americans with Disabilities Act, it's a closer call. But it depends on symptoms.
But you don't think it'll ever become like, oh, you know, he didn't get the job because he's Colombian, so that's not good. But COVID will not become a protected class in that way. Oh, they didn't give me the promotion because I had COVID. I don't have any symptoms or anything. But the mere fact that they found out I had COVID, they don't want to give me the promotion. Will it ever get to the point where the person can try to claim that they're being discriminated against because they had COVID?
Right, I don't think so, because most of the categories we protect are immutable categories. Some can change, well, I guess your age changes, but when it comes to race, religion is usually the same, national origin, you know, disability, that can change also. But these things are mostly characteristics you have in your person, sexual orientation, things like that.
But isn't COVID something that you got? It's in other words, if somebody got COVID, if somebody's African American, they were, to quote Lady Gaga, they were born that way. Mm-hmm. Well, if you get COVID, it's not your fault you got COVID, and in a way it's immutable because you're always going to have been somebody who had COVID. So
Yeah,
Sometimes you need to be a lawyer for somebody.
yeah. I mean, you'll always be in that
Will
category.
that ever fly?
But I mean, it's not. It just doesn't affect that many people long term. I think 5 years from now,
Yeah, but I guess what I was looking at is somebody doesn't get promoted because they had COVID, and they say, hey, that's the reason they practically told me that's the reason they didn't promote me. I'm going to sue them because of that, because it's almost like they're not giving me a promotion because I'm Chinese or I'm Spanish or whatever. It's like I got COVID. It's not my fault.
Right. Well, but you can hook that in under disability, saying COVID is a disability, and even if it's not, it's a perceived disability. So they perceive me to be disabled and unable to do the job because of.
So that would be the strategy that a lawyer would use. You'd be like,
I've used it.
You'd say, like, it would be better if we kind of look at it like they're looking at you like you're disabled. So.
Right, and that happens. That's not uncommon. There's a great quote in the case. School Board of Nassau versus Arline, Arline. That's Nassau, Florida, not New York. And they say, sometimes the myths and stereotypes about disabilities are more disabling than the disability itself. And you have this. I mean, you guys all seem pretty young in the class, but you had this during the AIDS. I don't know. They didn't call it a pandemic at the time, but now they say it was a pandemic. But during the AIDS pandemic, there was a lot of discrimination, and a lot of people were losing jobs, who didn't have access because they either had AIDS or were thought to have AIDS, and that was the reactions were maybe more disabling than the disease itself.
Okay. Olga, you have a question?
Yes, good afternoon. So the question will be about the salary history law. I work in a multi-specialty clinic that has more than 200 employees, and each of our offices has their own management. Let's say my salary or salary from the workers who work specifically in the location that I work have questions towards the management, as of my particular manager is not the one who is giving the work hours to the higher management, to the HR, for the checks to be written biweekly as our salary. However, if there is a question that she have to ask us, she always mentions how much we make, kind of saying, oh, be quiet because you make this much, even though she's not responsible to make all those payments.
Okay, well, the salary history law is a little bit different, so let's just review that. This only applies in New York City.
Yeah.
And it applies in the state to state employees, not to private employees.
Not to private, okay.
Right, in the state, but in New York City it applies. So the salary history law says when you're on an interview, the employer cannot ask, what was your salary at your previous position? All right, it's really, to me, it seems like it's really micromanaging the interview process to an extent that's just too much. But let me tell you what the reasoning is behind it. Maybe you've been underpaid. Your whole life, or for the last 5 or 10 years, you've been underpaid. You should not be punished for that by saying, I made X amount of money, and now this employer can sort of, pay you, or thinks you will accept less, or something like that. So that's the purpose of the law. But that just applies to, and by the way, the employer can't do indirectly what it can't do directly. All right, so it can't find out from a credit report or from some sort of authorization what your salary is. Even though it can't ask you, it can't find out another way. So that just applies really to the interview process. Once you're hired, the salary history law does not apply. And I mean, I think that's probably in the circumstance of of an employer being rude, as we discussed before. I don't think divulging other people's salaries violates any law.
Okay, thank you.
You're welcome, Moses.
Ray, you mentioned the New York State Human Rights Commission. So that so a good rule of thumb for the students to keep in mind would be that one thing is obviously the federal law, EOC, and everything else, but they should always, when they're researching or thinking about issues, they should also look at like what the state law is on something, right? Because obviously, as you have kind of brought up, state law could be very different, and they shouldn't just rely on, look, oh, federal law says I can't do this, so therefore I can't do this. They should also look at the state law, and even, I guess you mentioned New York City law, so
Correct.
they should look at all the levels, right?
That's right. That's right. The city law differs from the state law in some ways, and the state law differs from the federal law in some ways. So, you know,
So I'm not saying that but there's a lot of areas in law where federal, state, city is probably going to be somewhat similar. But in this case, it's definitely worth looking into because it could be wide differences that are worthwhile to keep in mind, right? So.
Sure. I think federal, state, and city all have different approaches to disability and the definition of disability and the interactive dialogue that's required for disability accommodation. So yeah, it's all different.
Asit, do you have a question?
Yeah, I just had a general question about what types of ways are these kind of cases usually settled, and what percentage of these actually go to trial?
All right, that's a good question. So I mediate a lot of cases also. And as a mediator, I always say, like all cases, this case will eventually resolve. It may resolve before a judge, a jury, a court of appeals, or it may settle today. All right, so the case is going to resolve at some point. The vast majority settle, probably 95% of cases settle. You know, but sometimes they settle on a letter. Attorney writes a letter, case settled. Sometimes they settle after a complaint. Sometimes they settle after a deposition. Sometimes they settle after summary judgment. Sometimes they settle on the courthouse steps after a jury is chosen. Cases can settle in a lot of. The fact that it's settling doesn't mean that you're not using judicial resources or court resources. You are. It's just a matter of at what point it's settled. So the vast majority of cases settle.
When you said 95% settle, I imagine somebody thinking to themselves, what do we need courts and judges for?
Right, and that depends on when they settle. So another effect of the novel coronavirus, the system was pretty slow and weighed down before the novel coronavirus, and now the system stopped for a while, and the federal courts have stopped for jury trials. Everything else is moving along very quickly in the federal courts, but the jury trials are not happening. They're doing one jury trial per day per courthouse.
It's funny you mentioned that, Ray, because the last time we spoke, one of the last times you mentioned about, I was telling my students became aware of this too because I incorporated it in one of the memos that I had them do, which is I got called for jury duty. And you had told me, hey, that's probably not going to happen for. So I got called. It was state court. So it was in Mineola, but apparently it was for state thing, whatever. To make a long story short, so I wasn't thrilled with it. But I went there and I sat there, looked at the wall for about 5 hours, and then they said it was adjourned. You're free to go. Here's your certificate.
Right.
Never seen so many adults bouncing out of a room, of a building like school children in June. So I came up with a memo question for the students. It was obviously not everybody got this question. I'm going to pose it to you, and you're going to tell us. Oh, wait a minute! I just realized some of them have to redo it. It doesn't matter at this point. They already did the first draft, so if they do an incredible second draft, who cares? Here's the question I'm posing to you. Let's say that somebody said, "Okay, I have an idea. Number one, we should create a job professional juror. In other words, people could train to be a juror. They would undergo training, like this is what the court system is about, this is what jury is about, this is what evidence is about. These people would be like better than the average person. They would be more trained in the civil, like in the court system, blah, blah, blah. And this could be a job. And the person would basically go and they would be, susceptible to going on juries. And, with a lot of people unemployed, underemployed, or, fired from their job or whatever, obviously it will go through a vetting process. And if you qualify and you become a professional juror, that would be your job. You would be in one jury, and then later on you'd be in another jury, like that. That's the first thing, jury job. Second thing, instead of paying people, you would allow people. I mean, I already know the arguments against this. I'm just going to throw it out to you. You allow people to pay $300 to get out of jury duty. Why do you do that? Raises funds. A lot of people are going to pay $300 to get out of jury duty. What do you do with that money? Maybe you could use it for programs or things that you need to help, for the court system or for people. Or you could also use it for part number 3. You raise the amount of money that people get a day from $40 a day to $100 a day for those who do jury duty. So you have professional jurors sometimes, you have regular people who are now getting paid $100 a day instead of $40. That might, encourage people to feel better about doing jury duty. And you would allow people to pay $300 to get out of jury duty. Tell me what's wrong or right or whatever or crazy about those 3 things. Go ahead.
All right, so number 1, we do have professional jurors. They're called judges. So not every case has to be tried to a jury. And right now, when I'm filing wage and hour cases, I am not asking for a jury because it's going to slow down the case incredibly. And you don't know what happens when a case doesn't come up trial for 5 years. I mean, maybe your client disappears, moves and doesn't tell you, goes back to the country that the client's from. Who knows? And it could happen with the other side, too. So there's just maybe the place you're suing goes out of business. There's just too many variables with it just makes it more arbitrary. So I am asked for bench trials by the court. So the Constitution grants you in civil and criminal cases a jury of your peers. So peers is supposed to be regular, ordinary people just like you and me and everybody on this call. They're not supposed. You don't want people with training. You don't want specialized people. That would also possibly tend towards corruption, right? If you know who the jurors are, that there could be corrupt, and there was, organized crime figures have been able to corrupt jurors, and if you know who the person is or might be, it's even more susceptible to that. So. I'm reminded of a joke where in a criminal case where the guy is representing someone accused of burglary, and the attorney is telling his client, well, you get a jury of your peers. He says, what does that mean, peers? The attorney says, well, peers, it means people like you. And the guy says, I don't want to be judged by a bunch of thieves.
Yeah. What about the, I know the argument against this already. I can see it coming. Here it goes. What about the people pay $300 to get out of jury duty?
Yeah, so again, it's supposed to be a jury of your peers. So, you're going to have people who can afford to pay that money to get out of a jury, being exempted from it. And then you're going to be left with people who can't afford to pay the $300 as your jurors.
Okay.
And, it's no longer peers now. You're really, it's,
well, not everybody's going to pay the $300. Some people are going to be like, well, I have the $300, but I don't want to pay it on that, and I'll just go to jury duty.
Right. But the people who can't afford it are going to be left in the pool, and you're going to have a skewed jury pool. Rather than it being random, it's going to be tilted towards, people who can't afford it.
So what about the cynical argument? We already have a jury pool composed of 70% of the people in the pool don't want to be there anyway.
Well, as George Carlin famously said, let me see if I can get it right.
George Carlin. He said a lot of things
George
famously.
Carlin, the comedian,
Yeah.
said, who wants to have a case tried before 12 people who are dumb, so dumb they can't get out of jury duty? They're too dumb to get out of jury duty, right? So,
the smartest, the most profound thing George Carlin ever said, and I will feel this till the day I die, because it was so profound that it's one of those things that it doesn't go away because it's that profound. He said, whoever drives faster than you is a maniac. Whoever drives slower than you is an idiot, no matter how fast or slow you drive. And if you think about it, that's true.
yeah. That's right. That's kind of like when politicians say, oh, taxes are going to be raised, or when people say, who's middle class? You know, and everybody thinks they're middle class. When taxes are going to be raised on the rich, you know, people are all for it as long as they're not in that category, right?
Yeah.
Yeah.
Well, Ray, let me see what time it is. 11:57. One last question, if anybody's got it. I don't see any hands up. You must have done such a thorough job that people are just speechless. Well, it was. I thought today was very, very cool because in other presentations we've had kind of a general thing, but today it kind of was. It tied into a lot of recent stuff that's happened with the vaccination. I thought all those stuff was interesting.
I see Kelly Lou has her hand up.
Kelly, did you forget to put your hand down, or?
No, I had my hands up for like 20 minutes, Professor.
For some reason, I thought I had called you. I'm sorry. Oh, I brought your name. You know what happened, Kelly? Sorry. Kelly's going to sue me now. She will get Ray as a lawyer.
Yeah.
I wrote Kelly's name here, and I thought I had already, and then I went to Olga. I'm sorry about that, Kelly. Sorry about that. So go ahead. Ask your question. I was testing you. It was all part of a psychological test. Go ahead, Kelly.
I actually had two questions.
Okay.
So
you get our money for now. Okay, go ahead.
In regards to salary history law, I've been on like multiple interviews in the past, and they have asked me like, how much did you make in your last job, or how much are you making in your current job? And I never know what to answer because I know that it's illegal for them to ask the question, but what can I do? I mean, if I don't answer the question, like they might, you know, feel like I'm being resistant or, you know.
Yeah, so that's a good practical question. I mean, if you don't answer that question, you're probably not getting the job, right? I mean, they want that information. So you know, you could answer the question, and if you don't get the job, there is a way to file a complaint at I think this goes to the New York City Commission on Human Rights. I'm not 100% sure. You'd have to look that up. I mean, it's a new statute, and it doesn't have a lot of teeth to it, but there is an agency in New York City that investigates it, pretty sure. But yeah, that's a tough situation, and a lot of times, well, here are some other tough situations. You sue in federal court, you know, now, let's say Kelly sues in federal court. Now, Lou versus Northwell is in federal courts. It's reported by these services on the internet, and if you put Kelly Lou's name in Google, on the first page, you're going to see that she sued her employer. So this is a thing that's affecting a lot of people now, and nobody wants to be seen as suing their employer. And this is, you know, you're on an interview, they're doing a background check. It doesn't take much to put somebody's name in Google. I mean, if your name is, you know, Richard Smith, all right, it's going to be difficult. But if you have a unique name, the case is going to come up, and that can adversely impact you also. So Kelly, I think you said you had another question.
So my other question is, can employers be held liable or legally liable if employees get COVID because they didn't have the proper precautions put in place, or they were just reckless and like had a party and was like, hey, you don't need to wear a mask. We're not checking to see if you're vaccinated.
Well, I'll tell you, and I had a case similar to that. So it was a case where somebody returned a shampoo, something like that, to a beauty salon, and due to COVID rules, that stuff can't be repurposed. You can't use it again. That's gone. You know, and if the person got their money back, that's a loss to the store. But this employer wanted to reuse it. I think she didn't want to resell it, but I guess she wanted to put it in the, you know, I guess when you shampoo people's hair or something like that, you know, you use it internally. And the employee said, no, you can't do that. You can't repurpose it. That's got to be trash. And they got into a big argument, fight over it. The employee winds up getting terminated after getting a raise like 2 weeks earlier. And we brought a whistleblower case under New York state law. So under New York state law, you can bring a whistleblower case if the employee complains about something and is terminated, but what you had complained about has to be related to general or public health and safety. Not an accounting violation, you know, not something minor. It's got to be public health and safety, and this fits the bill. I have also seen, although I haven't brought any whistleblower cases, saying, look, employers are required to have workplace requirements for COVID, whether masks, distancing, all this kind of stuff, and the employer didn't do it, and I got COVID, so that could be a whistleblower case too. I personally, I don't think I'd bring that one. If you can get COVID from anywhere, and I'm not sure, it depends if it's a threat to public health and safety. If it's a warehouse, it's only a threat to the employees. But if it's, like we said before, a beauty salon, yeah, that could be a threat to everybody coming in. But I haven't really seen that.
So there was a lawsuit. Did it get to the lawsuit state? Was a lawsuit over shampoo, a bottle of shampoo?
It was over, there was a wage and hour claim for overtime, and then we put this claim in also for the whistleblower claim for health and safety.
When students have asked me how wide can the law be in what it deals with, one of the things I always bring up, which maybe you remember this case from back when we were, I don't know which teacher you had. Did you take copyright law in NYU?
I did not, no.
Yeah, I took it. I had this lady, I forgot her name. She was obviously crazy about copyright law. And one of the areas that we studied was, one of the cases we studied was the people, and I showed the students all these trademarks. The trademark for Ghostbusters, 1984, I guess, is when that movie came out.
Right.
They were sued by the Casper the Friendly Ghost people because they said the ghost, the fat ghost in Ghostbusters looks a heck of a lot like, and they actually knew the name of Casper's friend. He's got like a fat friend. So and somebody actually knew the name of this guy, and they said that ghost looks a heck of a lot like the one that we have that's Casper's friend, and we're suing you. And you had Judge Sweet, I believe his name. How can you forget that?
Oh, yeah. I knew Judge Sweet, and now deceased, yes.
Yeah, you knew him?
Yeah. Well, I mean, I had cases before him.
Oh, okay. I thought you knew him. Okay.
No.
Judge Sweet was sitting in federal court in downtown Manhattan saying,
right.
There's only so many ways you can draw a fat ghost. And I was telling students that case alone must have gotten 10% of the audience interested in, hey, I think I want to be a copyright lawyer, because if I go to law school and I'm going to end up deciding cases like this, that sounds like cool stuff. The part that they forgot is that in order to be a copyright lawyer, you probably have to be at the top of your class, because it's a very popular specialty. And when you get out of the law school, all those jobs are scooped up by all the people at the top of the class. So if you're a regular person, by the time you get out, you're going to have to somehow work your way up there. It'll take you, 10 years to get into the copyright area. But the point is that it just gives you an idea of the different things that you can end up doing if you become a lawyer. You just never know where you're going to end up.
Right.
What things you're going to be arguing in court. you imagine somebody sitting in federal court thinking, I never thought they'd be discussing fat ghosts. This is, and the day before Halloween, I think that's appropriate.
Yeah, and intellectual property is pretty interesting.
Yeah. Well, and we don't have any more questions, and I know it's past the time, and I know you have your mom's birthday. Once again, happy birthday to her from all of us.
That's
And God bless her, many more years of life. And thank you for taking the time on the day of your mother's birthday, because I know that could be hassling. You got to get ready and everything. So we really appreciate it. It's always interesting. And every time Ray does a presentation, I always tell Ray, when you retire at some point, or you want to take a break, or maybe cut back on your regular hours, whatever, just let me know, because I think most people would agree. You can all raise your hand if you agree. If you think Ray would be an awesome instructor at Baruch, imagine him teaching a law class. I mean, students would be like transfixed. Look at how the hands go up.
That's very kind of you. Very kind of you.
People would be just from your experience alone, you could have people like mesmerized, So thank you again for taking the time to speak with us. We really appreciate it. We always do. And stay safe and take care and take it easy.
All right. Good luck to all of you guys. All right. Take care.
Take care, Ray. Thanks again. Take care. Bye.
Thank you.
What do you guys think, huh? What do you think of Mr. Nardo? Any comments? Very knowledgeable, huh? Must be.
He's very knowledgeable, yeah.
I mean, you just can feel that. I mean, 30 years experience doing anything, Somebody told me when if a sentence begins with he or she has 30 years experience, I don't care if it's making bagels. They are going to be, the experience will show, So it's 30 years is a long time to be doing anything. So it shows. So it's always interesting. I want to thank all the students who asked questions, and specifically Catherine, right? Catherine was the one that brought up the vaccine thing. Yeah, he said, "Oh, I'm surprised that it took half an hour." Well, the reality is, you kind of leave it up to what people are interested in, but it was a very relevant topic. So that's about it. Now, very quickly, for those of you who are Friday people, I hope they didn't leave. Some people might have left already. That's not nice. Okay, I have a way of seeing who was here. So if you're the Friday people, I did kind of get a thing where I get a copy of the students who were here at the time when I did it. If somebody came in after that, that's too bad. That was late, because I did it really late. I wanted to do it really early, and I ended up forgetting, and then I did it very late. So if your name is not on that thing, that means you showed up like really late. Which case, like really? So if you're from another class, from the Friday class or the Saturday afternoon class, and you come out in that thing that I did, I will keep a note of that. I was going to do a thing where I was going to have a code word, but then I realized, number one, that's just